Good evening, chat. Hello, welcome. It's Wednesday night, and yeah, sorry about last night. We're not feeling too good. I won't feel good, so tap. I tapped out, chat. I tapped out, chat. Couldn't hang in, but yeah, needed that. I think a little bit. Feeling a lot better now. Feeling a lot better now, and yeah, let's get to this. Let's get to this. Thank you for being here tonight, and we gotta push this up a little bit. There we go. There we go. Yes, whip him out Wednesdays. Yes. So, easy litter box cleanup says, "How can this be? It worked out great for Carl Chops and Smash JT." We are not going to talk about Smash JT tonight. We're actually going to save him for Friday. I'm hoping that there's some responses to some things that'll come in, and there. I need a little bit of time to get it all together because, oh my god, it's. I guess I'll just say I don't fucking get it. I don't get what's going on. I don't understand what's happening and why it's happening the way it is, but it's literally like it's just not ending well, chat. It's just not looking good. Oh, I forgot. Yeah, his attorney. Yeah, yes, J. Remy Green. Which once again, we're gonna talk about that. Hats off to J. Remy Green and the goobers over at KOSK because they have pretty well committed to psychological warfare and fucking with Ron Coleman, which once again, Chad, I've told you, that's part of the battle, whether you think it is or not. It's not just sit there and go, here the law, here the facts, blah, blah, blah. Like, that's a good part of it. But if you can fuck up the other side, then you can cause all kinds of havoc. So yeah, once again, hats off to them for causing everything to come into a disaster zone. So says Sean, get better mods that don't interrupt towers. What did they interrupt? Well, it's a Clyde. It's sure, but Clyde's face on it is allowed to interrupt wherever it needs to. It needs to use AI to prepare my streams. That would be so fucking gay. Imagine doing that or putting AI in your fucking description. Imagine doing that instead of just fucking like typing it out. Like, come on now. It's even for something like Supreme Court cases, you can just literally like copy and paste off of like a million different websites and then piece it together. I mean, if you're using AI in your descriptions, oh, buddy. Oh, buddy. I mean, it's not like we're talking about fucking astrophysics here. Not like we're talking about astrophysics. Erica said he's going to be late. Was I late? I don't know. You tell me. You tell me. Jasmine Cat Dude says that trial done in Tip City. Are you talking about in Ohio? Talking about the guy in Miami County? Hold on here. Unless you're talking about Tip City, Indiana. But people call, you're talking about the Caleb Flynn guy, right? I don't think it's going to trial on the 28th. I don't think it can happen that fast. I just don't see it. I don't see it. So that might, like, I appreciate it, Jasper. If he does, yes, I'll cover. Well, here's the problem. That starts on the 28th. So 28th, yes, I could actually see. We'll cover it at night because I'm going to be busy. Like, the end of the month here kind of sucks for me. End of the month is, let's see here. 28th, yes. 29th, yes. 30th, yes. The first, yeah. And then I have like the 4th, 5th, and 6th. I have a 4-day custody trial. Well, at least let me put it like this. The court's like, this is going to be a disaster. So we're setting aside like 4 days for it. So maybe at night that week, it'll be maybe a little tougher. I don't know. We'll see how it goes. I don't know. Just warning you now, chat. Just warning you now. Something to keep in mind, something to think about. But yes, if it's available, I will watch it. I don't know if it's going to be televised. If you do find out it is televised, send me an email when Phil's not watching and let me know. Let me know. Chip's like, look, man, 90% of law tube is incredibly lazy. I mean, yeah, well, okay, yes, but not that lazy. Yeah, the jury selection is 20th, 29th. Yeah, which 2 days is pretty normal. 2 days is pretty normal. Is my bathroom always reflected in that frame? The bathroom is not in the frame. He is not there. You are just making things up now. And then Dirty Eric for $5 says, I need Sean to explain why KBJ's dissent at Childs v. Salazar is so wrong. Well, we can do that. Just not tonight. Just not tonight, guys. You guys are wondering what Childs v. Salazar is. It is the Supreme Court's opinion that came out that Colorado's ban on conversion therapy for minors is applied to counselors who are doing talk therapy. It's a First Amendment violation. Because yes, trying to talk somebody about chopping their penis off or cutting off their tits is apparently a hate crime in Colorado. Because, we can't have that. We can't have them saying, wait, I don't want to do that. Jeremy, you guys see Jeremy in the bathroom reflection. Luke says, I'm going to be honest, as the only person in chat who kind of likes KBJ, every once in a while she does a pretty good opinion. But like when it's 9-0, yeah, she does great opinions. Like her one about the employment discrimination was fire. But overall, yeah. Yes, any First Amendment opinion of hers is kind of trash. Yeah. Yeah. We can see your door is open. Well, the door is open, but the door opens. If you guys have watched if you guys go, you go be a member, you can see the studio tour. It opens up. There's a little hallway here, and then there's a bathroom right next to me. So, like, if I walk out this door, I turn left into the bathroom. If I turn right, I'm in, if I walk forward, I'm into a hallway that's, just a little alcove. So, David is saying, does this apply if I send an AI chat to myself? That's actually a good question. We'll save that for later. What are your thoughts on the potential lawsuit by Jeremy against Ashton or Andy or even Josh? He's not going to fucking do... Oh, I mean, like, come on now. Like, what's he going to sue them for? I mean, number one, what's he going to sue for? Number two, even the biggest thing, does he have any money? Remember, that's the big thing. Like, Jeremy's broke as a joke, it sounds like. Like, he's a brokey. He's got to pay for his fleet of 15 airplanes and RC cars and all this shit. Like, I can't imagine he's got enough money to do that. And what has he said? What have they said that's defamation or anything like that? Everything that's been introduced is something that Jeremy said or talked about. When you invite a guy who's a swinging bull over to your house, people are allowed to imply you're probably letting that guy ball out your wife. So maybe there is no Skyrone, the Sky Bull. Maybe it's just Jeremy's buddy coming over to ball out his wife. We don't know. We don't know, but it's reasonable to conclude if you invite a swinger over to your house, you're swinging. I mean, it's reasonable. If you invite a drug addict over your house, yeah, people have the right to infer you're doing drugs. He could sue Andy and Ashton in California. They have civil rights tribunals. He might, but he's got to come up there to do it, and I don't think it's going to work. It's just he's going to have to fucking suffer. I mean, if he sues, it'll be hilarious, and I'd be willing to help the farms, help them out whenever, help out Ashton and Andy. However, if Jeremy is really going to act like that big of a cuck, that big of a bitch of a man, and he's going to try to sue them, Fucking the cuntering is what we're dealing with. Let me tell you what. Yeah, suffer, Jerbo. Yep, basically. Justin says, what if you have a whore living in your second house? Well, it all depends. Where do you fuck that whore? Do you fuck the whore in the second house, or do you let her come over to your first house? I mean, there's a lot of logistical concerns and technicalities that need to be ironed out in that fact pattern. When her wife was just, what a great time to tune in. Yes. But hold on one second, chat. All right. What if you meet a swingers resort in Jamaica? Well, the biggest thing is don't help pay for the abortions for the girls in Jamaica. Don't do that. I mean, yes, the biggest thing in Canada is Jeremy would have problems because he's on the right in these Canadian courts, especially if he sues them like in Ontario. Oh, Commie-tario. All the commies in Ontario and up in the Toronto area. Oh my God, they would feast on Jeremy's soul. So that would actually be funny to dare him to run headlong into the communists. Like, do it, Jeremy. Do it. That'd be hilarioso. I know the deep lore. I was there when it was written. You speak of the lore. I was part of the lore. Don't talk to me about knowing the lore. Motherfucker, I'm part of the lore. So I don't know. Like, Jeremy will show up with his fucking tangerine coffee and they'll want to put him in prison. So still don't understand that one. Tangerine based coffee. Doesn't make any sense. Yes. I am the law. Yes, I am the law. All right, chat. I ate the Lord's sandwich. Yes. Tangerine coffee goes hard if you're a cuck faggot. Yeah, well, don't say F slurs. Say like PHAGGOT. Be phonetic. Yes, I was forged in the lore, cast in the law. Coffee that can't even ship to Canada. Yes. I don't know how he sells it. Because he gets people like, help me do this, you'll own the libs. And everybody's like, I want to own the libs. And it's like, I want to throw them out of fucking helicopters. But apparently, for a lot of these boomer cons, that's good enough. That's good enough. That's all they want. Tangerine coffee is likely an infusion with the oils from peel. No. I understand, Malcolm. Like, they're probably using like oils. I just can't understand how that tastes good. That just sounds fucking disgusting. I mean, it like, I don't know, but I think most coffee flavors are kind of nasty if it's not. I mean, I just think like like my favorite K-Cup's the donut shop coffee. It's like, that's actually pretty good. So, Missouri Battleflex says, where the hell you been? I was afraid you had a heart attack. Nope. Just I didn't feel good on Tuesday night. But we were live Monday night on locals. So, you like chicory coffee? I've never had that, but I could try that. I mean, the one thing I do want to try is from the one channel I used to watch a lot, myself. The guy does like that Chagas tea or that Chagas coffee where it's like the mushrooms they make coffee with. I'm like, that actually sounds kind of interesting. I'd try it. Also, chat, I guess I'll show you because while I was sitting here feeling miserable and wanting to die, I made something. I finished it up. I kind of been playing with it over the weekend. Check that out. I made like a little set of barrels on a pallet for bolt action. And they're pretty close to size. I mean, look, here's a guy. And here are the barrels. Like, it's pretty close in size. They're a little big, but that's okay. Learn how to make terrain. Let's see here. Community Coffee sucks. Is Coffee Brand Coffee a new sponsor? He'd have to give me a couple $100,000 for that. I'll sponsor all kinds of shit before I'll sponsor Coffee Brand Coffee. And ultimately, at the end of the day, you know what? Like, real coffee chat. You want real coffee from a real man who has real beliefs and real positions and keeps it real and stands on his business. The T-Man does over at the Dragon's Treasure. He sells tea and flavors, and that should be flavored, but he just sells coffee. He doesn't act like he's got a bunch of roasters. He doesn't have a whole factory working for him. He doesn't make any of that shit up. The man just sells his fucking coffee. The man sells his coffee. He doesn't back down. When someone tries to bully him on the internet, he comes back and whips his dick out and smacks him right in the face. You bust out a 3-year-old DM on the T-Man, and he's like, motherfucker, the world's changed since then. He's like, the world's changed. My principles are still the same. That's how you know the T-Man is. Show him some love. Buy his tea. Use the code criminal for 10% off. So, do they take Clyde coin? No. Will he do a Clyde brand coffee? No. Yes, he sells coffee now. Teas, soaps, and coffee. Yes. T-Man does it all now. T-Man does it all. And you know what? We'll pull it all up. We'll pull it up here, chat. We'll do a little bit of exploring. So you guys, as Monty Monograph says, you need to get learned. He sells, guys. Look what they sell. They sell soap. They sell foot soap. Oh my god! If you're a fucking creepo, and you want to look at soap you can whack it to. I mean, I don't really think you should do that, but if you really want to, you can beat off to the foot soaps. I'm sure the T-Man's like, no, that's not what I want, but you can if you want to. For all you true degenerates out there, foot soap. But T-Man sells coffee. No gimmicks, chat. No gimmicks. Demon's extract. What is it? What do we got here? Dio. What is it? What do you got here? It's got some whiskey acidity, floral aroma, creamy body, notes of chocolate and citrus. Well, there you go. I was about to say tangerine shit's bad, but anyways, I'm still betting it's better. Roasted confession. All kinds of stuff you can get here from the T-Man. Show us foot soap and says to say no gimmicks. That's a little different. Gooning isn't a gimmick. Yeah, unnamed gooners don't use the soap to wash with, so you can get away with selling the miniature sizes. He's got focus drinks. So you can help concentrate, chat. So when you're at camp and you're trying to concentrate, you could concentrate better. Is T-Man apolitical, though? No. He is unapologetic in what he is and what he does. If Melanie Mac came to his door, he'd say, get the hell away, you hoe. That's how base T-Man is. So. Cocaine imbued shampoo. Gooning isn't a gimmick. No, it's a way of life. It's like the meme. Gooning wasn't a phase, Mom. It's a lifestyle. Anyway, let's get Sui Generous says cool show. Well, thank you. So let's move on though, guys. We had a little sidetrack there. Get thee behind me, Satan. Clip that, Alyssa. B2B3 says, I bought some Dragon's Treasure recently using the code criminal. As I drank it, I ascended into Hyperborea briefly. It was that intense. Based, chat. Absolutely based out there. VTubing says, I sent you a DM. I meant to the boy. I did. I saw that. I am going to answer you back. That requires a little bit more of a. I kind of wasn't in the right headspace yesterday. I was like, kind of like, and I wasn't even answering emails yesterday. I was like, fuck, I don't want to do that. So I was like, I'm just going to like kind of, I just sat here at my thing and I was just kind of like staring in and out at stuff. You might think, well, Sean, you probably what you do most of the days. Maybe. But at least now I'm doing a smile on my face. I will get back to you. I will get back to you on that. I did see it. That's on my list of things to address. After that statement, Sean, I'm using the code COPE. That's fine. You want to cope, chat? Go ahead and cope. But that's who you are at the end of the day. You're coping. You're coping, and soon you'll be seething. So I thought it was a code copium. It's still always code COPE. It's code COPE. So Spughead saying, fuck, I ain't doing that. It sounds like work. I mean, yesterday afternoon and evening, I was like, I'm not fucking doing this. Worry about it tomorrow. And I did. I worried about it today and I got it all done. So did I quit huffing airplane glue? Never. You gotta that keeps me balanced, man. Keeps me balanced. If I leave a pile of dead hookers on your doorstep, can you add it to your list of stuff to address? Yeah. C3 says the patio open at Stoney's. I mean, the patio is always open. You can always walk out to the patio at Stoney's at 1580 Broadway Street in Rockville, Minnesota, chat. Yes, patio is always open. But is it like open? No. I mean, bike night's the end of the month, April 30th. So it's like, it's kind of got like a soft opening. It's always there. But, you know, Naked Twister season isn't even happening till May Day. That's right, chat. April 30th, you know, Friday, May 1st, you want to celebrate May Day, International Workers' Day, and the Comintern. Play Naked Twister. That's right. You want to celebrate communism? Be a big faggot. And that's one way to do it. That's one way to do it. So, at Stoney's, although I have a feeling Cheeto is probably not a big communism fan. So, yeah. I'm stalling. No, it's time to go. People are bringing up stuff. All right, chat. Let's go. Did I see that? Yes, Rex Hoyerman confessed. We're going to cover that tomorrow night. That'll be kind of fun to address. Also, I first thought that guy's haircut was like his jail haircut. No, that's that guy's haircut like all the time. And if that was his haircut all the time, how did any of those hookers get into a car with him thinking, oh, he's not going to fucking murder me? I mean, if you got no car with a guy like that, oh my God, he's going to kill me. Silly Old Fidget says, Nick said he's going to skip the HRO. What are your thoughts? There's no way he said that. There's no way. No way he said that. No way he said that. No fucking way. There's no way he said that. Where did he say that at? I mean, I can't imagine he would say that because if he didn't show up, that's the easiest way to make that HRO a fucking reality. So I don't buy it. I don't buy it. Hold on. 2.0 is bringing up, does that violate probation? No. That is a civil case, so it wouldn't be a violation of a court order. No. You could be on probation and get restraining orders against you. That's nothing you do about that. It's a lesser standard anyway. He said on Twitter he wouldn't show up. If he's dumb, like there's no way. He's just talking shit. Like if he won't, like if his ass isn't getting back on a flight and the court doesn't approve it, which I am surprised the court's kind of dragging this out. Although judges sometimes do fuck around with parties and, you know, you're like, hey, judge, you know, you call it the bailiff. You're like, hey, is the judge ruled? Nope, he's busy. And you're like, is he busy or is the judge just sitting there taking pencils and going right into the fucking ceiling? Sometimes I feel like judges do that. I'm not gonna lie. Sometimes if I was a judge, I'd probably sit there and take a pencil and, like, do you guys ever do that as a kid where you had like the foam ceiling, you take the pencil in your hand and you just like, I don't want to do it here because 2.0 fucking get angry. You take the pencil, you just right up into the ceiling. I have the feeling judges do that. I have the feeling judges do that sometimes. So what if he gets held in contempt? I don't think he's going to get held in contempt. The judge could say, I thought that, the judge could be like, all right, well, they default. I mean, there's different things he could do. Maybe. I mean, I don't know. He's not going to get held in contempt. And that wouldn't trigger probation anyway. All those probation officers are going to be like, fuck you doing, homie? But, who knows? Who knows? And then real quick, Tyler for $9.99 says, regarding AI, and let's get to this. Yes. As a non-lawyer, I'm curious how it would be purely for research. Not using a model trained on a legal data set, but referencing it. The two things are very different. I don't know to tell you, but I have been reading things about AI lately, and I think that when it comes to legal stuff, AI experts like computer scientists and engineers have said they don't really think you can have a non-hallucinating AI when it comes to court cases. Like, it's almost impossible. But we'll get to it. We'll get to that. We're going to get to that here. It's a very good question, Tyler. I'm going to save that for later. That's a good one. That's a good one to have up for later. All right, chat. So, no, the judge hasn't said it yet, but apparently we're still waiting. We're still waiting. Yeah, and that's also the other thing. Lolcows have plot armor. Yep, they do. They have better plot armor than in a Greek tragedy or a Greek play. Yep. So anyway, chat, we're getting on to AI. Artificial intelligence, large language models, all these things learning, you know them as, there's Claude, which is Anthropic's thing here. I mean, there's Grok, there's Open AI, there's Chat GPT, there's all kinds of AI out there. There is even, in Westlaw, which is one of the big things out there. It's the competitor to LexisNexis. It's called CoCounsel. Lexis has Lexis Plus. And it's, with Protege is the actual AI solution. And you're like, there's all kinds of it out there. And it can't be trusted. And there's a bunch of stuff that's come out, guys. And first of all, we need to start on this. This is a case we're gonna talk about. This is a great example of things. This is gonna be fitting for Thursday or Friday night when we talk about Smash JT. Erica says, "Is it cheaper?" I mean, it doesn't do the fucking job right. So it's cheaper, but it doesn't do the fucking job. So anyway, this is a case out of the Southern District of New York. This is the United States of America versus Bradley Heppner. Now, what did this guy do? Here is the thing. So what does Bradley Heppner have? Securities fraud. Okay, it's just a criminal case. He was involved in securities fraud. He took over a financial services company that did secondary life insurance, which is a different market that's out there. There's, primary life insurance, but you can get secondary life insurance. There's all different things you can do that. So he had this business. He took over a company called GWG. They took an interest in a benefit company group. And it was a services company started by Bradley Heppner. And, what they did was they allowed people to move around with cash and do things like that. So he goes through all this. There's a bunch of debt. We don't really worry about all of this. But just so you understand, he's facing a bunch of charges. A bunch of fucking criminal charges. And very serious stuff. So what's he got here? First of all, well, count one was wire fraud. Count one securities fraud. Count two is wire fraud. Remember, chat, when you're stealing money, you're committing fraud, you're going to do wire fraud. structuring, tax evasion, all those things go hand in hand. All those things go hand in hand. Okay? Conspiracy to commit securities fraud and wire fraud. We're looking at a lot of time in prison. Count 4, false statement to auditors. You don't get to do that if you have a publicly traded company under the Securities and Exchange Act, and you can lie to auditors. And notice it's all in a count in connection with an audit review or examination of financial statements made in preparation of a document required to be filed with the SEC. Notice, it's not even you lied to federal agents. You lied to the auditors who are doing stuff for your company. Remember, when you're publicly traded, the rules are different. Count 5, falsifying records. This guy's in a lot of trouble. You're like, okay. So you're like, all right, that's a bit of an issue. Here. Okay, we'll come into February and we get this thing here. It's a motion from the federal government. And what do they talk about here? Well, they cite a bunch of cases. So what happened? So this guy got charged for a bunch of stuff here. Now they talk about what happened. The guy stole ultimately $300 million. And yes, the government's going to notice when you steal $300 million, the government's going to look at you and say, yeah, we're not cool with that. Believe it or not, chat, you can't do that. So what did they say though? Well, so basically he tricked that company. These companies became intertwined and he defaulted on his own debt, and that required GWG to pay for it. And he used, he was personally received over $150 million of the funds because he owned all the debt. He paid more than $40 million to renovate his Dallas mansion and $10 million for his personal credit card and private air travel. So what did he do here? Well, in November of 2025, he got arrested at his home. So while they were there, they seized dozens of electronic devices, which that happens all the time now. Shortly after the search, defense counsel informed the government that before his arrest, the defendant had run queries on the government's investigation through an AI tool, Claude, created by a third party, Anthropic. Defense counsel further informed the government documents generated by the AI tool, by the prompts and the AI tool's responses, that is, the AI documents would be located on the devices the government had seized. Now, you might say, why did the attorney say that? He had to, because the government was going to find him anyway. Oh, wait. Oh, that's funny. We'll talk about that later, Ag. That's fucking hilarious. Well, yes, that's the problem here, Elliot Johnson. You got to send your $300 million to Somali learning centers. Yep. Now, they say to date, defense counsel identified approximately 31 documents which comprise the AI documents. Counsel asserted such documents are privileged. At the request of defense counsel, in an abundance of caution and pursuant to a privilege protocol stipulation, the government agreed to segregate AI documents from the prosecution team, pending resolution of the privilege question. Very much like with Donald Trump. They had a taint team. They had independent parties handling documents who weren't with the prosecutor's office but were part of the DOJ. And the defense attorney would say, here are all the documents, here's what's in them. And they could examine them to see if there's privileged material or not. Can we get the text in bold? No. And they say defense counsel has subsequently provided the government with privilege logs that identify certain documents. And guys, a privilege log is a very critical thing you have to do. And it's not just saying, oh, I have privilege. You have to say what the privilege is, what the document's roughly about, and what, is all of it privilege? Is none of it, what's all privileged in it? You have to have a little bit of detail in it. And they say the government has continued to engage. In doing so, defense counsel informed the government the defendant included inputs for information the defendant learned from his counsel. Defense counsel further informed the government that the defendant created the AI documents for the express purpose of talking to counsel and obtaining his counsel's legal advice, and that the defendant did in fact share the AI documents with his counsel. The defense counsel has not claimed the defendant used AI or prepared the AI documents at counsel's direction. Now, that's an interesting thing here, guys, because we get into issues of attorney-client privilege, but then there's also an issue of work product. And those are going to be some things we have to deal with here. Nor has counsel claimed any other involvement in the creation of documents. That's correct. So trial begins on April 6th. I think it got kicked out. I don't think he's gone to trial yet. But they say in order to prepare, the government seeks a ruling. Now they say attorney-client privilege, and here's where things start falling apart. Yes, attorney-client privilege is between a client and his or her attorney that are intended to be, in fact, kept confidential for the purpose of providing or obtaining legal advice. Yes. It's the sacrosanct thing. You guys are saying red underline sucks? Okay. I don't know if you guys are being super serial or not, so we'll just go ahead and do it. I can't tell sometimes with chat. We'll just go ahead and do it. And they say for privilege attached, the predominant purpose of the communication must be to render or solicit legal advice. So yes, if you guys call me and say, hey, Sean, how about the Indians last night? And we're talking, that conversation is not privileged. But if at any point you start talking to me about legal stuff after running like, oh, by the way, I'm getting indicted. Can you help me with that? Yes, then privilege would start applying. So privilege may be invoked only to hold secret only those communications made in confidence to a lawyer to obtain legal counsel that have not been made without the existence of the privilege. Because remember, if there was no such thing as privilege, nobody would tell their lawyer anything. But because that privilege is sacrosanct, that's why people make the conversations and disclosures. And they say the privilege must be narrowly construed because it stands in derogation of the search for truth so essential to the effective operation of any system of justice. And it is. Without it, it would be impossible for lawyers to do their job. And it becomes an issue, for example, like Legal Mindsets mentioned this in Japan, there really is an attorney-client privilege. There's no such thing. It's like in a lot of nations, that's not a real thing out there. What if I say, hey, Sean, how about those H-1B Indians last night? Yes. Now, does it play any lawyer? Well, no. I mean, some people don't keep confidence, period. But do that as you will. But yes, the privilege ultimately belongs to the client, and Missouri Battle Flag is correct. If you are my client, you have the privilege. So if I'm speaking to you about something, we're talking, it's your privilege to waive. Now, there are times where I can breach that privilege. There are very limited circumstances where I can either discretionarily do it, and there are times where I mandatorily have to do it. For example, if you're committing a fraud on the court, I can't help you do that, and I have to notify the court. There's times where, depending on your state, if you're going to kill somebody in Ohio, I don't have to lift a finger to stop you. Some states I have to act, but in Ohio, I don't have to. It all depends on where you're at. But generally speaking, it is your privilege to waive. It's also your privilege to lose. And here's the point. And it says the party invoking privilege bears the burden of establishing the applicability. And that's correct. You're the one asserting privilege. It's like an affirmative defense. You have to state why you don't have to talk about it. The burden is heavy. It is. It's not a light one. And they say because it stands in the way of the search for truth, it must be narrowly construed. Now think about that. They're admitting that attorney-client privilege would destroy the justice system if it was more lax in its application and scope. And if the bar for attorney-client privilege was low, then the system could be ground to a halt. You might say, well, that sounds based, and I agree, but notice how the government's telling on itself here. Missouri Battle Flag, as a court officer, aren't you a mandatory reporter? I'm a mandatory reporter for child abuse. But then it becomes a discretionary thing, too, because it's attorney-client privilege at that point. But I have some limitations on if I'm a guardian ad litem, especially, like, then I don't have that. I have a duty to report, but it becomes an issue when you're the attorney. It becomes a bit of an issue there on how that works. Hold on here. And I was going to bring up the Ohio rules of professional conduct here. But when you're talking about mandatory reporting of child abuse, that's where it becomes that becomes a bit of an issue here. So, if you are in a special relationship, it becomes a bit of a sticky wicket, but you try to avoid being in those situations. But here is where I think it's important to discuss. This is a different state here, but this is a general. Come on, load up. I clicked yes, and it's not doing its thing. So here's my rules of confidentiality in Ohio. AI gave you the unprofessional rules of conduct. Yeah. So anyway, so here's the things. I have duties. I have duties and obligations to follow. I have duties and obligations to follow here, chat. And here are the big ones. I shall not reveal privileged information relating to representation. And at times, that can also be considered the existence of the relationship. Do you represent that person? I'd argue sometimes that's protected if nobody knows. I shall not unless a client gives informed consent. And they say, or the disclosure is permitted by Division B or required by Division D of this rule. So let's go down the Division B is permitted, saying, I may reveal information if I reasonably believe necessary to prevent certain death or substantial bodily harm. I don't have to, but I can. To prevent the commission of a crime by a client or other person. I don't have to. To mitigate substantial injury, the financial interest another has resulted from the client's commission of an illegal or fraudulent act in which they've used my services. Now, this one here is where to secure legal advice about the lawyer's compliance with these rules. So once again, I've mentioned this before. I go to an ethicist or a lawyer who does a lot of ethics stuff, and I can say, hey, what do you think? You can bounce ideas off other attorneys. To establish a claim or defense on behalf of the lawyer in a controversy between the lawyer and the client. To comply with other law or court order. To detect and resolve conflicts of interest from the lawyer's change of employment. So I might have to disclose a little bit of information I know. Say, hey, does this person do this, and this? Yes. Okay, well, I can't be involved in that. Now, notice, I shall reveal information if I reasonably believe necessary to comply with Rule 3.3 or 4.1. So what are those? And notice, the shall is very short. Well, what's Rule 3.3 and 4.1? Oh, those are pretty easy. Rule 3.3 is candor towards tribunals. And the Rule 4.1 is truthfulness in statements to others. That's it. That's it. That is all I have to do. So you have no duty to act in Ohio? Holy shit. Yeah, well, you shouldn't. Ohio takes confidentiality very seriously. There's shit I will take to the grave. All kinds of shit I'll take to the grave that's fucked up and nasty and fucking awful. I take it with me. I won't ever give it. I'll never tell. No matter what. Once again, Ohio's a hard state full of hard men. That's right. You heard me. Hard men. The hardest men. Let's get back to this. Let's get back to this now. Now, from here, they point out, though, what do you do? Well, so they point out that's the standard for attorney-client privilege. Got to be for the purpose of securing information and advice in preparation of legal defense. Um, uh, okay, I'll answer that in a minute. But now we move on to this thing called work product. And this is a separate but kind of intertwined doctrine here. All right. So what is this? So the work product doctrine is distinct, but it's kind of gets intertwined at times. So it provides protection for materials prepared by or at the behest of counsel in anticipation of litigation or for trial. So if I start making notes on something, like if my client sits down and talks to me and I start putting together notes or I start doing research and coming up with things, that's work product. You don't get that. You can't subpoena that. You can't demand it in discovery. Well, also, I can be prepared for or at the behest of counsel. Well, what does that mean? Well, that's the big issue. At the behest of counsel. What does that mean exactly? We're going to get to that. We're going to get to that, chat. It's kind of important. Now, documents that are prepared in the ordinary course of business, like business records, are not work product. They say work product does not shield materials in an attorney's possession that were not prepared by the attorney or his agents. Now, they say there is a narrow exception to this principle where the material in question has been selected and compiled in a way the party asserting the privilege shows a real rather than concern of that the counsel's thought process would be revealed in the documents. So if I make you produce certain documents in a certain way or certain things, that may reveal my thoughts and trial strategy. That could, but that's a very narrow exception. And not every selection and compilation of third-party documents transfers material into attorney work product. Now they say, how do they haven't met their burden of establishing privilege. And here's the big thing here. The biggest thing that destroys privilege, attorney-client privilege, spousal privilege, doctor-patient privilege, penitent priest privilege. Now, not every place has priest and penitent privilege. Any sort of privilege you may have that you can assert. What's the biggest thing that destroys it? A third party. So, for example, if you or if an attorney, if you, me and you are discussing your legal case and we decide to go to a Panera Bread and we're sitting there talking openly about it and everybody can hear us, well, there's no privilege to what we talked about. For example, you tell me, yeah, I robbed a gas station. A guy sitting at the table next door could go, boop, 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 call the prosecutor, be like, hey, man, I just heard this guy admit to it. He's a witness. He can be used. That's legal testimony. Okay, so now there's ways you try to suppress that and all that, but third parties destroy privilege. That's the quickest way to destroy privilege. Now, that is the big thing at issue here. That is the biggest problem. Oh, and then what does this turn into? Well, they point out he hasn't established his burden of proof. And they say that, the defense said once the defendant got these AI prompts, he sent them to defense counsel. Here's the thing, guys. When you send stuff to your attorney and you're like, I learned about it on AI, or they're going to know right away you did AI, number one. And number two, they're going to look at it and be like, oh my fucking God. Don't be that guy. Don't fucking be that guy. You're not helping. You're not helping when you use AI. All right. Um, it doesn't turn non-privileged AI into a privileged tool. They point out that these are not protected by attorney-client privilege. They're not communications. They were not made for the purpose of obtaining legal advice. And they're not confidential. Now, the first thing is they are not communications between the attorney and the client. AI is obviously not an attorney. Yeah. The attorney-client privilege does not attach to non-attorney communications. And there's, the government saying it's no different than if he had asked his friends. And yes, discussing legal matters with non-attorneys does not imbue them with the privilege. That's correct. All right, guys, sorry. And they say, ultimately here, and that's the problem here. Now, they point out that the AI tool has no law degree, is not a member of the bar. It owes no duty of loyalty or confidentiality. It owes no duties to courts, regulatory bodies, professional organizations. Now, they cite a Harvard Law Review article in Technology Review. Here's the bigger problem. They were not created for the purpose of obtaining legal advice from professional legal advisors. Now, they point out Anthropic's constitution indicates that one of the principles is choosing the response that least gives the impression of specific legal advice. So that's a big issue. Oof. And instead suggest asking a lawyer, which I'm sure it probably did. Additionally, if asked about giving legal advice, Claude states that it cannot give legal advice and you should consult a qualified attorney, which is always true. Consult a lawyer where you live. They also point out you can't claim that you used it when it explicitly disclaims that use. And the biggest thing of all is they're not confidential. It's an AI tool that's run by a third-party company that's accessible. And the biggest thing is when you feed data into an AI machine, it uses your prompts and your information to learn more and do more things. So now you've shared it with the world. Now, obviously, nobody could go and find it specifically, but you've breached the privilege. Everybody can expose to it. Everybody can take a look at it. Jefferson Post says, could Destiny's use of AI be part of discovery? Yes. Yes, if Pixie's attorneys don't, based on this, and honestly, here's the biggest thing. I can't believe people are using fucking AI. So if Destiny really was using AI, he's a fucking idiot. He shouldn't be using it. Don't use AI. I mean, this case right here, when this came out, I didn't know it came out till about a month, like about 2-3 weeks ago. I now have in my emails, my email disclaimer, the first thing, I have a confidentiality notice, that states like, if you receive this in error, please destroy all copies of the message and contact me as soon as possible. If you are not the sender is intended for, please do not read further or open any attachments. Like, there's a confidentiality notice on these things. The first thing I have at the top now is instead an AI/LLM warning and disclosure that you inputting any of this information in this email or in any documents will violate attorney-client privilege and can be discoverable by opposing counsel. Do not consult with any AI program or any open programs or I basically say don't consult any computer program at all with legal questions relating to your topics. You do so at your own risk and you expose yourself to a lack of attorney-client privilege. Like, I have that in there now because people fucking do it. And it's like, I'm making it the first thing people read because it's that big a deal. I almost have to, like, the back of my business card right now says, do not talk about your case with anybody but your attorney. I'm going to have to say that includes artificial intelligence. Don't talk about it with Grok. Because how long till local, like this is a federal court case. How long till local prosecutors start trying to subpoena this shit? I don't know. I don't know, guys, but it's not good. It's just, this is bad. This is bad. Hold on here. You guys are asking some questions. We'll get to those in a minute. But yeah, he further accused to receive AI-generated responses drawing upon a wide range of sources. As this was not a mystery to the defendant, Anthropic states in its privacy policy, which is in effect, that it collects data on the prompts entered and outputs generated. It uses this data to train the AI tool, and it may disclose this data to government regulatory authorities and third parties, which could be other people involved in the training of AI. It could be involved with shareholders or the government if they want it. They say for these reasons, users have a diminished privacy interest, in which users voluntarily disclose to an AI company, which the AI company retains in the normal course of business. Which there you go. And they say fourth, this sending it to your lawyer doesn't help you at all. It doesn't work. It does not cover you. The sending of AI searches to counsel after the fact does not make them privileged. Now, they say any advice offered in response to the documents would be presumptively privileged, but you can't extend that back to the information in the underlying documents. So they're saying basically for these reasons, he can't meet his burden for attorney-client privilege. They'll say they're not work product. But, they point out they weren't done at the behest of counsel in anticipation for trial. The attorney conceded the AI research is not prepared at the behest of anyone, including counsel, which you'd have to be fucking insane to tell your guy, hey, fire up Grok and look shit up for me. The defendant took these actions himself without any direction from counsel and then shared the products with counsel. The defendant acted alone and transmitted materials to his attorney. The fruits of the action are not work product. They say, had counsel directed the defendant to run the searches, the analysis might be different. That would be that would be malpractice if he did that. Honestly. I don't think that would be, I would never want to do that. That would be really bad. They point out though, the work product doctrine preserves a zone of privacy which a lawyer can prepare and develop legal theories and strategies, free from unnecessary intrusion by his adversaries, which is true. An AI product does not fall within it. Okay, so the government asked for it. Well, chat, this came out just after Valentine's Day, and like I said, this didn't make big news for a while. It took a while for this kind of filter out into the legal world. But this, buddy, wow. Think about this. In a federal case where your, rights are more protected than a civil case, which is like way down here. Criminal case, like all the way up there. Still. And Luke is correct here. Yes. Yes, a priest penitent privilege, which is, somebody confessing their priest or seeking guidance from their priest. Some states allow for it. Not every state does. Was asserted in the Josh Duggar case, which is one of the Duggars who was diddling kids. And I think another Duggar's a diddler now, was defeated because the priest's wife. Yes, remember, third parties defeat the privilege. And a church where only men can take leadership roles is present. Now, there's an interesting wrinkle to that. Let's say this is a situation where it's a husband and wife pastoral team. That would probably be okay. Like, I can make an argument for that, and I can see that argument surviving. But if you're just a, it's just Pastor Bob and his wife coming over to talk to you about, you fucking little kids. Well, that's, Miss Sally can't be there Now, Miss Sally's part of the church team, okay, but those are going to be very fact specific. It's going to be very fact specific. Patty says all priests have privilege. It doesn't matter what the state says. Well, that's a separate issue. Many like Catholic priests, they have, the confessional seal. They won't reveal things at all. That becomes an issue in some other religions. I don't know what the Protestants would do. I'm assuming the Protestant priest will fold and waffle because, that's, remember, Protestant religion's founded on being a quitter. Every one of them. I don't like this. I quit. I'll start my own church. Every time something happens, like, I'll quit. I quit. Yes, there is another Duggar diddling, yes. So they point out here that the government's going to say what happens here. So they point out that AI is a lot of different things, chat. And to be fair, I'm not, like AI does a lot of stuff. Google, when you're searching for things, it's doing stuff on its own of its own accord. You're commanding it to do something. Search me out X. Okay, that's an AI. This right here. This is David Hinkins says, what is a Protestant priest? I don't know, whatever they call pastors or whatever they call themselves. But this, for example, chat, this is the CISIS. This is the kind of an off-brand Lexus, like it's the Lexus you have at home, thing I get from the Ohio State Bar Association. I have other things I can use, but this is one I think I won't get in trouble for showing. This uses AI. If I start typing in case law and stuff, I could start typing blah, 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 done. It's using artificial intelligence to search and generate results. Yes. But it's a little different here. A little different what we're talking about. So, ultimately, they point out that more than half of United States households have adopted AI in some form. Yeah. Roombas, Alexas, all that stuff. They say only 3 years after its release, one prominent AI platform is being used by more than 800 million people every week. And they say, yet the implications for AI on the law are only beginning to be explored. And we're talking about that tonight. And they say whether ultimately, what is it? For these reasons, the answer is no. Now we're not going to get into the whole backstory because we're already past that point. We need to get to the discussion here. And we're going to get to the actual breakdown of stuff because they make some discussions here. So I start with attorney-client privilege. What is attorney-client privilege? Well, it's between a client and his or her attorney that's intended to be kept confidential for the purposes of providing legal advice. You're like, there you go. There you go. Courts construe it narrowly because it operates to an exception to the rule that all relevant proof is essential for a complete record and for confidence in the fair administration of justice. Yes. Remember, the government has an interest in convicting people and exercising its monopoly of violence on everyone. So that's why you're seeing that. Remember, chat, once again, this is the government asserting its monopoly on violence and its authority over you. But they're saying that's why it has to be narrowly construed, because we can't do our job and put people in jail in a metal box. Or as Chili DeCastro might say, in torture cuffs. Applying these principles, AI documents lack at least two, if not all three elements of attorney-client privilege. First, it's not between the defendant and his counsel. Tyler says, you answered most of my questions by showing decisis. Well, so I'm curious, how would it be purely for research, but not using a model trained on legal data sets? Well, here we go. What I'll do is, we can talk about Here, we'll bring this up, Tyler. I think this is kind of what you're asking about. Okay, so burglary, enter, hold on, open burglary, open door, force. And that's, we're kind of asking some questions here. Okay, well, okay, that didn't come up with what I was looking for here, but we'll bring it up in a second. But part of burglary in Ohio is, you have to use force, stealth, or deception upon entering a home. Okay, well, what is stealth? Okay, yeah, stealth's like fucking Mission Impossible, or deception's like you trick somebody. Okay, but what does force mean? That means like kicking in a door or opening a door. Yeah, opening a door is force. But let's say the door is already open. What does that lead to? Well, here's some cases. And I can do relevance. I can do by highest court, lowest court, jurisdiction, A to Z, date, newest, oldest. I can do, court rules. I could do this, the Ohio Revised Code. I could do the Ohio jury instructions, which are, how they're set up for burglary. Trespass and habitation to it's like low level burglary. It's kind of like the best thing because you don't go to prison on that generally. You can have different, like the Ohio Administrative Code. You can have A to C decisions, which are like the Ohio Board of Tax. Yeah, I mean, there's a lot of stuff it can do. And here's the thing, though. If I go into court and I cite this case here, State versus Armstrong, this is a Court of Appeals decision, the 8th Appellate District, Cuyahoga County, out of Cleveland. Cleveland has its own appellate district. If I cite this, and it's in the reporter as 2021 Ohio, page 1087, and I go down to paragraph paragraph 18 here, I would cite paragraph 18, and that would be an effective citation. And let's say a court somewhere says, Sean, I don't think this is right. Did you check it? Well, at this point, I'm allowed to assume this is an accurate citation. I don't have to check this, okay? This is basic search. It's almost like if I found it in a book. If I open up the book and I found that on a page, I would be able to use it. I would be able to use it because at some point, there is a basic reliance on things. But notice here, they point out with respect to the element of force, the necessary amount of force is minimal. Merely opening an unlocked door, can do it. And they say entering an open door satisfies the element of force in a burglary offense. Notice they're saying entering an open door satisfies it. Well, that's not the case anymore, actually, in Ohio. There's actually a case in Ohio that says that's actually not the case anymore. That's actually not the case anymore, which is fucking hilarious. Because this is a case in Ohio. It's State versus Bertram. And what happened is, what happened? Well, the guy, he was landscaping his house when a car pulled up. He made contact with the guy who drove past his house, and the guy came back. The homeowner said the guy got out of his car and started walking towards his garage. The homeowner said that the guy basically acted very cavalier and had no sense of urgency. Just boop, 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 boop. The guy strolled into the homeowner's garage with a smile on his face. And he didn't think the guy was going to steal it from him. But what happened? The guy saw a leaf blower around at $500 and walked back to his car. And the homeowner's like, stop, put it down. And the guy put the leaf blower in his car and drove off. And the homeowner got photos of him. The guy got convicted of burglary. Okay. So the guy got basically, and here's the problem. This guy got a 500-day parole violation. Judicial sanction for post-release control. Basically, he's on parole. He got 500 days mandatory in jail on top of a indefinite prison term of 8 years. So basically, he got 13 years in prison for this. So, yeah. They ultimately say, this is, they point out that the guy did not engage in secret, sly, or clandestine conduct. He did not use force, stealth, or deception. He did not commit burglary under Ohio law because he walked into an open door. So, just spurging on that sidetrack, but you guys know that. But anyways, Tyler, I'm glad I kind of answered your questions. So, would a beaded curtain count as a door? I don't know. Or what if it was one of those things where you go through it and they come back together and the magnets click? I bet that probably counts as a door. I'd argue it's an obstruction you have to forcibly go through. Anything you have to go through would be a door, I think. So, decisive references cases law in terms of my question. Okay, well, there you go. There you go. Yeah, so that's like the limit of things. That's like the limit on things. So, and then Tyler says, you answer most of my question by showing decisive. Well, I'm glad. And that's how, if you fire up Lexus or Westlaw and you just use it as a search engine, that's what you get. You use Boolean operators. You could do different things to search, but that's limited. And I'm not liable for that if it's wrong. At some point, like, you got to rely on it. And like, let's say I used a case like that. Supreme Court of Ohio's like, fuck you do. And you'd be like, I did nothing wrong. The court's going to be like, yeah, you did it. But they move on here. They say, in the absence of attorney-client relationship, the discussion between two non-attorneys is not protected. They say the court is aware that Claude as an attorney is irrelevant because the inputs are more akin to other internet-based software such as cloud processing applications. But the use of those is not intrinsically privileged in any case. Like, yeah, if you're using software that stores in the cloud or it's cloud sourced or anybody can look at your stuff, oof, that's not good. You know, privilege requires a trusting human relationship. It's important. It's important. You can't have, that's one of the big things AI will never be able to do. It's not a human. A licensed professional who has fiduciary duties to the discipline. These documents were not confidential. It's because the written privacy policy provides that the data goes to train Claude, and they reserve the right to disclose that data to a host of third parties. Can't use it, chat. Can't use it. You may disclose your data to third parties. Grok is the same way. All that stuff. It's not protected. They also point out that there's other cases where in this district, the Southern District, AI users don't have a substantial privacy interest in their conversations. And that was the case with OpenAI, copyright infringement litigation. And they say, finally, third, he did not communicate with Claude for the purpose of obtaining legal advice. Now, the judge is saying this is the closer call because the attorney asserts that Heppner communicated with Claude for the purpose of talking to counsel and preparing it. But the Heppner didn't do so at the direction or suggestion of counsel, which, once again, God help him if he did. Had counsel directed to use Claude, Claude might arguably have said to have functioned in a manner akin to a highly trained professional who may act as a lawyer's agent within the protection of attorney-client privilege. Maybe. But here's the problem. Even if that exists, you check one box, you don't get to check the other two. Like, remember, you got to have all three. You have to have all three elements. If you don't, you have two, you fail. If you have one, you fail. You need all three. Without all three, you have nothing. So, Luke is saying, would a chatbot set up by your attorney be different? Actually, I don't know. Because if you go to we'll do this here. We'll do here. These guys are kind of like the big attorneys here in the Northeast Ohio area. Kissling Nessico Reddick. Here's a chat bot. I'm not a current client, and I talked to an online agent. Here's the thing. I'm actually, Luke, this is a very good question here. Let's look at this. We don't know. Yes, KJ. You got to make it airtight, chat. You got to get all 3 holes. This is actually a very good question here. Cleopatra says, I'd argue unless the attorney sources the bot from a reliable source or didn't build it himself, I'd say it's unreliable if it doesn't say ask a lawyer. Well, this is the chat bot for a local law firm here. What's the privacy policy? I mean, more importantly, this is their privacy policy for them. But what's their privacy policy with the company that operates this? Notice that this is an issue here. Have they checked this? Do they know the answer to this? So let's see here. The data is processed at the owner's operating office, any place where the parties involved in the processing are located. Okay. Data transfers may involve transferring data to a country other than their own. But I mean, how does this work here? You know, this is the biggest thing here. This is your data between them. But what's the data policy between them? Like this law firm, what's their data policy between their law firm and the company offering the service? That's a good question, Luke. I don't know the answer to this. Because this is a this is not really a good privacy policy. Yeah. I wouldn't trust the privacy policy of AI companies. Well, that too. Yeah. Don't use it. You don't know where your data goes. I understand, but that more importantly, does the law firm know where this is going actually? Luke says, I presume a law firm that sets that up in the way that waives privilege. Well, have they thought about this? I mean, is that even something they've considered? Because up until this past year, you wouldn't have thought of, like, if there's a guy I follow on Twitter, Rob Frund, he's an attorney. This AI shit has exploded in the past year. Would you, like, this is something I'm actually kind of curious about. Yeah, most likely they don't. Yeah, and cloud-based, yeah. I think these guys, like, I'm not going to shit talk them, but like any lawyer who has this setup where because you guys have been to law, like lawyer websites and this chatbot shit pops up. Although technically, fuck. I might have a problem in my own chat here. This is actually causing me to panic now a little bit. Go to the Martin Law office. You go to contact. Contact me. Brief description of your legal issue. Yeah. Technically, this goes through the website hosting company. I bet they actually retain the right to look at that information. Yeah. Wow, you can be like, in cases where this happens, then you can be an extremely melanated lawyer going forward, putting AI demands and stuff. I'm not screwed, but I'm like, I can see this being an issue. Jane Reed says, anyone use that? Yeah, I got quite a few things for people. But it's just something to think about. Like, do you need to make a moment to call your hosting company? No, I'm just saying, Keep Pat I see you use Cash App and Zelle. Well, I mean, Venmo, like, well, Cash App, yeah, dude. If you're dealing with like certain people, that's important. Been there, done that. Says, what if they use a Google search instead? Well, you probably wouldn't be able to find the Google search necessarily. But if you use AI and you don't delete your AI searching, that stuff's going to be available. But this guy like created documents from Claude. Like he gave Claude spit out like Word documents for this guy to read. So yeah, this is interesting. I'm sorry, Chad. I'm like, this is. I hope you guys understand. This is kind of like this is live action riffing right here. Like, how protected is this shit? How private is this shit? Yeah. Huh. Huh. I'll be dipped in shit. I'll be dipped in shit. Huh. I can get a private AI that's on a closed container, but that's not worth shit to anybody. And even then, Topher, I wouldn't trust it to not hallucinate still. Megan Mobass says, could you put a disclaimer on this? Says any type in this box may not be subject to attorney-client privilege to cover your ass. Oh God, yeah, but I mean, if you do that, are you ever going to want to fucking talk to an attorney through a website? I mean, that would just be fucking insane. That would be fucking insane. Could you discover the government's AI usage? Sure. If I mean going forward, I probably will. You know, in discovery demands for court like criminal cases I have, I'm going to start demanding that. That's something I actually have thought about. That disclaimer makes it more likely the privileged wage, but feels like it's a malpractice issue for the attorney. Well, yeah, it is. But now I also have noticed this being a potential issue. Huh. You guys kind of blew my mind with that. This is why I fucking love you people. This is why I love you guys. Like, this is some serious ethical obligation issues. Like, governing the practice of law. Like, how does this work? I'm not panicking, no. But it's like, you guys, thank you for making me think about this. Adam says they're communicating to me. How's that not protected? Because Weebly is the company that runs my web hosting. They probably my user agreement probably have access to all this data. Third party has access to it, therefore it's not privileged. Yeah. Think about it. If you typed in this, yeah, I fucking killed him, please help me. That's a confession. So, could I argue the same thing with talking to any client over an internet call or even phone calls? Surely, no. I think at that point you can argue you have a basic protection or implied protection and an implied privacy there. That's going to be very difficult. The intent that that's protected, because technically, like if you call somebody on a cell phone, really technically, a cell phone is not like you can intercept cell phone calls. They're not encrypted. But, you know, generally speaking, everybody has an expectation of privacy in their phone calls. So, no, I think you'd be safe there. Huh. But yeah, you guys helped me out a lot here. Sorry for that sidetrack, but that's really important. Huh. So, would your email still be privileged? I mean, technically, you'd like to think so, but does that count too? How far is that? How far are courts willing to say third parties could see stuff? You know, that becomes a problem because you don't run the email program. You know, even if I have my own web hosting, the web hoster is going to have access to that stuff and can see that stuff. Even if you're on a secure thing. Yeah. Huh. Yeah, well, Google searches your emails. Everything you send through, Google looks at. Same thing for Microsoft. Like, the only thing allegedly isn't Proton, but who knows what they do anyway? They could say no, but that doesn't mean no. You know how many attorneys have a Gmail? A fuckload of them do. You know how many attorneys have Outlook? A fuckload of them do, myself included. You know, basically all attorneys, like everything. Yeah. How does email differ? Doesn't it go through my? That's exactly my point. That's exactly my point. Razor's Edge. Technically, there's no privilege. I mean, where does that go? What about HIPAA compliant AI services? I don't know anything about those really. So, yeah. Even if you hold a custom email domain, someone else still host it. Yeah, that's the thing. Even if I have it all on SeanMartinLaw.com, it's not going to work. Also, somebody asked what the P is for. It's because there's Sean P. Martin. And that's very important in Ohio because there are two of us. And I'm not joking when I say that there are literally two of us. There are two of us. And we're pretty close in time. It's not like one of us is like 50 or 60 years older than the other. So it's kind of interesting here. And the funny thing is, this guy's office is out in Wyandotte, Cary, Ohio. That's kind of out by Toledo, and I used to work in Toledo, so we got each other's shit all the time, like court filings. It was kind of important to be Sean P versus Sean A. Yes, because Ohio's full of mix. Well, that's true as well. Yes. I've been told this guy's actually very, very pleasant. I've never run into him, but like firsthand. So, Kia Pack says, would states or Topher is saying, would states need to make new laws about AI, or would that be something the bar decides? The state can make a law, but that doesn't mean anything. The privilege is still determined on how a court would interpret it. P is stored in the balls, Martin. Yeah. Sue him to meet him. I'm not going to do that. Yes. Sean's a patty. The name Sean implies I'm a patty. Come on now. So, has Ricada ever yelled at Sean A. Martin? No, but I know some people have tried to A-log me and got in touch with that guy. So, because they're fucking idiots and they A-log the wrong dude. So, anyways, let's get back to this. Oh, wow, chat. I'm going to have to do some digging and discussion with that. I hope I don't set off a firestorm, but that's kind of a problem. It's kind of a problem. I mean, yeah, am I going to have to start my own hosting my own server in my house along with a VPN to secure the routing? I recommend. I mean, that's the problem, but even if I do all of that, once it gets to you, it's going to be unprotected. I wouldn't be able to secure it anyway, because once it gets to your home and your computer and your account, it's going to be opened. Because if you have Google or anything else, like web traffic is, well, BL says your server will handle your emails. But if you have Gmail, which everybody has, that email has to land in your mailbox, which is open to the world. So BL says that won't be your fault. Yeah, but that's, yeah. You can issue email addresses to your clients. That might be the only fucking, like, God, you want to fucking bankrupt lawyers, like, doing all that shit. Fuck. It's hard enough to communicate with clients half the time that I have to give them a fucking email address to use. Buddy. I ain't doing that. I don't know, man. I don't know that. So, Let's let me point out anyway. This guy communicated with Claude of his own volition. And, the government asked Claude whether it could give it legal advice and responded, I'm not a lawyer and can't provide legal advice or recommendations, and went on to say, consult with a qualified attorney who could assess your specific circumstances. That's a problem here, guys. That's a problem. That's a... They then talk about work product doctrine. And this is the thing, like I said, it's kind of intertwined. It's related but distinct. And they point out here that ultimately, the doctrine provides for materials prepared in anticipation of litigation or for trial. And they say it's not generally promoted by shielding from discovery materials in possession that weren't prepared by the attorney. So that's the thing. As a client, if you give me stuff or in a civil case, I generally have to turn that shit over. It has to be a real rather than speculative concern of, whether or not this would reveal litigation issues. And the AI documents don't merit it, because even if you did for the sake of argument, say that they were prepared for litigation, they were not prepared for by or at the behest of the attorney, nor did they reflect defense counsel's strategy. Yeah. So ultimately this goes on, and what do they say? So they say AI's novelty does not mean that its users are not subject to long-standing legal principles. They say because the use of Claude fails to satisfy either rule of attorney-client privilege or work product, they don't merit protections. So therefore, they are fair game. Fair game. Fair game, chat. Fair game indeed. Now, I know a lot of you guys are going to say, well, what about Alyssa Mercanti and Smash JT? Save that for Friday. Put a pin in it. But yes, this is something to consider. Now, from here, though, AI hallucinates, and this is a big thing here. This is the case of Hannah Payne. She got into a self-defense shooting because some drunk asshole was running away, and she got prosecuted for a citizen's arrest, basically, in the Ahmaud Arbery aftermath. This is in front of the Supreme Court of Georgia. And listen to this. This is the state arguing their stuff in front of the government.
So before you sit down,
yes, this is a prosecutor. This is the prosecutor's office now.
There's one more thing I need to ask you about, unfortunately. In reviewing the trial court's order denying the motion for new trial, there are at least 5 citations to cases that don't exist. And there's at least 5 more citations to cases that do not support the proposition for which they're cited, including 3 quotations that don't exist. My understanding is that you prepared the order for new trial, the denial order for the trial court. Were those citations in the version of the order that you submitted to the trial court?
No, Your Honor, I do not believe so. They were not. I did prepare an order. That order was revised.
We're going to review this later, chat, because Brian Steele worked on the appeal in this case. So did Andrew Fleischman. He's one of the attorneys down in the Atlanta area. I follow him on Twitter. He's a very knowledgeable attorney. I actually follow him, get a lot of trial tips and advice from him just by watching his tweets. But no, they literally provided the court with a bunch of bullshit, and the court adopted all of it regarding especially the motion for a new trial. A motion for a new trial built on hallucinated cases. And the government knew about it and didn't change it until the court forced them to do it. ACOG says, can we talk about citizen's arrest? We'll talk about that with Hannah Payne, because we're going to go through her appeal, and we're going to talk about a bunch of stuff here. But it's the idea you can arrest somebody in the act of committing a crime. So it's not that you're robbing me or, but like if you're burglarizing a house, if like you're burglarizing a house across the street from me, I could come outside with the AR or the shotgun or whatever it is I got in my hands at the time. Maybe I just come over here and, reach over and I reach over and I, bring out my Italian friend, Mr. Beretta. I take Mr. Beretta over here and I come outside. I'm like, get on the ground, motherfucker. That's a citizen's arrest. They're kind of dangerous. Generally speaking, let the police play that game, because if you kill the guy and there's an oopsie poopsie, you don't get qualified immunity. So I would be very careful about doing that when you can. But or I could pull out an assault Clyde. Anything I could do. You got to be careful. Got to be careful. Dirty Eric says, I perform a Getz arrest. Well, yes, the Bernie Getz school of crowd management is not a bad idea sometimes. So notice she's like, uh-oh, I'm in trouble.
So those non-existent cases were cited in your initial brief opposing the motion for new trial.
We're going to cover this more, chat, coming up, because it's all still out there. But yes, this new motion for new trial where a woman got convicted and is spending 20 years to life in prison. The government made fucking AI cases up.
Your Honor, I'm not aware of that, but I would be glad to research that and provide the court with a supplement.
Okay, we'll get a briefing order out directing.
Yeah. Not a good day for the prosecutor's office there. Not a good day for the prosecutor's office there, chat. Not a bit. Steele and Fleischman didn't spot this, which is definitely an oopsie on their end. Honestly, Luke, they didn't, but here's part of the issue, and this is something you generally trust the opposing party, especially the state, not to be fucking dicking around with AI like that. I mean, they're the prosecutors. They have paralegals. They have interns. They have all kinds of staff. Like, they're not the type of people who should be they have all the time in the world. They get to do whatever the fuck they want. And they're using AI. They shouldn't be fucking doing that. I wouldn't expect it. Especially, but that happens to, even the best. That's the thing. Andrew Fleischman and Brian fucking Steele. Guys, they are, they're the best you can get. And, this guy here, by the way, this is what I'm talking about. Andrew Fleischman, chat. Very good follow on Twitter. I get it. He's, you may not like him because he's on the left and he's left wing and all that, but he does a lot of great work. And I love the work he does. It's very good for what he does. He's one of the best around. Luke is saying it means any relief from pain for this is likely waived. I don't think so. I think this is a clear error. It's clear. I'd argue it's clear error. That's a sua sponte thing the court can get involved in. It's error that it has to address. Because also, by the way, I got blocked by the quartering. Also, so he said something about our girls opening up OnlyFans, and I just responded with, can your buddy's wife with the big tits start an OnlyFans? And Jer got mad. Oh, so yes, I got blocked. The client was a poor dude and the court appointed him. Seems like we might see this case again with AI and the indigent court appointed clients. In Hannah Payne, I don't know if she had a public defender or not, but no, generally speaking, court appointed, you're You're seeing it like everywhere, though. I mean, that's the thing. You're seeing it everywhere, and it's only getting out of control. Only getting out of control. I mean, this issue would be the first case that would come up. I'd likely be processed through an ineffective assistance counsel lens on their end. Yeah, I agree. But I think it's clear error. The court relied on erroneous shit. But anyways, it's going to keep moving here, chat. There's all kinds of cases here where, AI is just spiraling out of control and people are doing crazy, crazy shit. And it's not just these civil cases, guys. It's just not these civil cases. It's criminal cases where it's starting to happen. It's getting out of control. It's even in the Sixth Circuit Court of Appeals. Guys, federal appellate court stuff is happening now. Federal appellate court stuff. This is a guy's criminal case. And it's just, whoa, buddy. Whoa, buddy. Yeah. Luke says, I think I've seen a single case dealing with AI sites. Well, that's because that's brand new issues mean brand new theories. And yes, I would argue the presumption of correctness is gone. I'd say it's clear error because it's an erroneous order from the court because the court directly adopted it. Also, the district attorney barely having implied the attorney you showed just got suspended. Yeah, but even then, that attorney still needs to get disciplined. And who knows? Because those DA's offices down there are corrupt as shit. I'm actually going to try to reach out to Andrew Fleischman, see if he's got any more information on this stuff for Hannah Payne. But anyway, this is a case, United States of America versus John Ferris. Guys, this is... Whew. So this is per curiam. This guy's appeal is challenging his sentence of imprisonment. But they don't under-resolve the merits. They resolve the conduct of his attorney, who was appointed to represent him by the Criminal Justice Act, which is, you get on the CJA appointment list in federal courts, the Criminal Justice Act. By his own admission, he used artificial intelligence to draft briefs and then filed them without properly verifying the authorities. The result was multiple misrepresentations of law. Okay, so what happened? The guy pled guilty to crimes. He at sentencing, he qualified for a 2-level enhancement, meaning he got fucking jacked up. After that, the court authorized, so the guy was initially appointed to represent him in his criminal proceedings, and then he got to continue serving on. Sometimes that happens, but generally speaking, it becomes an issue because you can generally file ineffective assistance counsel. Sometimes, though, you want to stick with the case. And they say, upon our review, we began to suspect that generated were released in part by artificial intelligence software. The first tell was the file name of the principal brief that he fucking put on the electronic filing database. Co-counsel skill results. Co-counsel is the name of Westlaw's internal AI interface platform. Like I said, guys, this guy used the AI for Westlaw. Not Grok, not Claude, not fucking dildo smear. He used Westlaw. And they say they're like, from our vantage point, like our skills of detection say that file name abnormality suggested the brief might not have been derived from independent work. Further suspicion arose. During our review of the briefs, we discovered 3 problematic citations. And they cite the United States Sentencing Guidelines. Page 10 cites a case, of in Washington, which that's not Strickland v. Washington. And they say page 10, the principal brief states, likewise in Anthony, you have these are quotations. You have to back up. You have to back these shit up. The reply briefs repeats the latter 2 quotations. And that's, remember, chat, when you do an appeal, a lot of times you file your brief, the government responds or the opposing party responds, then you get one more reply. They repeat the two quotations. So not only did he once, he did it twice. He did it twice on two separate documents. Each of these references genuine legal authorities, but the purported quotations don't appear. So that's the thing. This 715 Federal 3rd at page 985 is correct, but it doesn't say this. And this one is not correct either. They say, upon deeper review, we couldn't locate any legal authority that contained the same or substantially similar language above. So not only did they do that, they copied and pasted this shit into like search engines. So it did not appear that the misattributions involved mere citation mix-up or transcription errors, which, once again, Chad, I've said before. Let's say you do 715 Federal 3rd at 985, but you meant 589. That's not a big deal. Like, you shouldn't do that. You should always check to make sure it's accurate. But let's say I typed in page 589. You know, I meant page 589, and instead I did 985. A court of appeals might be like, counsel, please be careful in the future. But that's not a big deal. That's not a big deal. That's not a big deal. Because it, like, look, it was an easy, like, you know, there have been times, though, I've seen cases before where, like, court's like, hey, man, what the fuck was this? I don't understand it. And you're like, you see the parties like, okay, I had to fix that. That's not a big deal. You shouldn't do it, but that's okay. Like, in terms of things, like, that's not that big a problem. They say, moreover, the briefs filed misrepresent the holdings of the two cases, U.S. v. Washington and U.S. v. Anthony. They say in Washington, this court, meaning the Sixth Circuit, upheld an enhancement under United States Sentencing Guidelines 3B 1.1. That enhancement was not reversed, as the principal brief asserts. And although the court did vacate an enhancement in the other case, it did so narrowly based on the proper counting methodology applicable to that enhancement, chat. And if you guys want me to, I'm not a federal guy, but like we can talk about the federal sentencing guidelines. I mentioned that before. If that's something you want to get into, remember, it's like a 600-page behemoth that details all kinds of stuff. Okay. They say, indeed, contrary to the briefs, the defendant conceded his role as a director and supervisor. They say, based on these discoveries, we directed the clerk to issue a show cause order in February 2026. That required Howe to provide a copy of each authority cited in his briefs from either Westlaw or LexisNexis. And this is where, chat, like if I use Decisis and they say, Sean, where the fuck did you find this? I would go, I pull it up. And the neat thing is here in Decisis, this court case right here, State v. Armstrong, we talked about earlier. The neat thing is I could download the document and it comes up and look what I can do. I have this here. And this is basically, if you guys are looking at this is the Lexis format. I would print this out and I would say, here's what I have. And they go, oh, okay, that makes sense. You have some reason there. But from here, guys, they asked him to discuss any discrepancies between the real authorities in his briefing. He had to explain who wrote the briefs, whether AI was used, and the process to use a site check the briefs, and to what extent Howe used AI in any district court filings in this case. So not only at the appellate level, but they're saying, whoa, buddy, in his underlying case that we're dealing with, did you use AI there in the order to show cause? Whoa. Now, there's a good question here somebody asked. Adam says, what if the paralegal lies instead? That's your fault. The paralegal is your employee. So if I have a paralegal, if you're my paralegal and you do all that and I don't check it, that's my fault. Okay? I'm responsible for it. If in the middle of an appeal to the United States Supreme Court, you just started writing the N-word 50 times over and I didn't check it or remove it, that's on me. You could get in trouble too, but like ultimately I'm responsible for what goes out the door if my name's signed on it. Thanks, babe. I love you. What? Yeah, funny. I understand, babe. I understand. But anyways, they do it, and they say, Hal filed a timely response. In it, Hal admits he used AI to prepare both briefs, which, if you fuck up, you got to admit to it. You have to own up. You have to own up to it. According to how he directed an unnamed staff member to upload district court documents to Westlaw's co-counsel program to create a first draft. Then he worked in that same file for 6 hours to supplement the draft produced by AI. He notes he repeated that same process for the reply brief. By way of explanation, he claims appeal was his first time utilizing co-counsel in this way for a court of appeals brief, and he says that he is otherwise unfamiliar with the program. He states that his law office first acquired co-counsel in August after district court proceedings, and that no AI was used to prepare documents before that. He notes he's never been disciplined in his 40-year career, which is also very important, whether for improper use of AI software or otherwise. This is a big problem. Boomer attorneys and older Gen X attorneys doing this shit. He agrees the briefs contain legally erroneous content that was generated. He concedes that 3 inaccurate quotations were the product of AI. They don't appear, and the briefs misrepresent the holdings. He admits those occurred because he failed to review and verify. He accepts full responsibility for that. And honestly, that's important. If you fuck up, you have to own it. You have to own it. You have to own it. And this guy's owning it. Yeah, that's a thing. Yes, just like a tradesman, you're responsible for your apprentices. Even though a paralegal is not your apprentice, it's your employee. So, Zakuza, yes, but saying I'm like a 60-year-old boomer. I don't understand how this shit works. That is a bit of a defense, but at some point now, it's not anymore. They say, how is the latest artificial intelligence misstep our court has confronted? We therefore write to reiterate attorneys' baseline ethical obligations as they relate to the use of AI. So now everybody in the Sixth Circuit better notice, everybody in the legal profession must be clear-eyed about the pitfalls. The mandate's true because of AI just being crazy. Hal claimed that he was not familiar with co-counsel. Okay, well, that's great. The risk of reflexively relying on AI are well documented. ABA has already commented on it. Attorneys should not utilize technology without knowing the ways it can be misused or be inaccurate. Very true. That remains true when new tools are sponsored by trusted legal technology providers. Remember, just because Westlaw says it's good, you're still responsible for it. Now, remember, guys, that is way different than me just going like, I'm using this. Very different. Very, very different. Very different. And they say attorneys who choose to use AI must do so in a manner consistent with ethical obligations. We don't purport to exhaust the full scope of considerations here, but relevant steps may include reviewing and validating content, considering whether to disclose the use of AI to clients or obtain informed consent. That's another concern I have. Like, you guys understand from the ethical standpoint, do people want AI involved? Do you need consent for that? Part of like a retainer agreement I have with people is I reserve the right to confer with outside counsel. Not necessarily that bill with them, but like I have the right to ask, hey, Bob, you handle these type of cases all the time. Is there anything I'm missing? Safeguarding confidential information and preserving privilege. Implementing firm-wide policies. And that's a thing, does Westlaw's thing have privilege? Adhering to ethical billing practices when using AI tools. Because, yeah, did you write that? No, someone else wrote it. Then I didn't spend 3 hours writing it. Is that unethical? Yes. Keeping current with jurisdiction-specific guidelines. Some courts make you certify that you didn't use AI. They say new technologies are no substitute for tried-and-true safeguards. Attorneys have an obligation to verify citations. It's a duty of competence and candor. Attorneys who rely on AI must remain diligent in supervising their work and carefully examine accuracy. And a reliance on staff rather than himself or another attorney, even if it's another attorney, it's still your fault if you sign on the line which is dotted. To preserve this work product fell short of his obligations. He did cite real legal authorities. That doesn't absolve him, though. The failure to verify the output still resulted in false quotations and misleading legal arguments. They say, we appreciate the timely response, as well as his candor, his honesty, and the improper use. And we take note this is the first time a court has had to address his misconduct in the practice of law. But the fact remains he committed a big fucky wucky. That misconduct has consequences. Among other things, it required a significant use of judicial resources to investigate the AI, coordinate a response, and facilitate steps. So they order appointment of different appellate counsel, further delaying this guy's appeal. This guy's in fucking prison for. That this guy was serving as appointed counsel for an indigent defendant only compounds the harm. So the guy does not get... So what happens? He's not going to get paid for any work he did. He can't bill for it. The clerk shall forward a copy of this to the Chief Judge of the Sixth Circuit Court of Appeals to consider disciplinary proceedings. The clerk shall serve a copy of this on all the courts, the Chief Judge in the Eastern District of Kentucky, the clerk, and the disciplinary clerk for the Kentucky Bar Association. In Ohio, that'd be the Supreme Court of Ohio. Additionally, by separate order, remove Howe from further representation, or the clerk to appoint replacement. They're going to lock the briefs filed, meaning they're going to basically be locked and they're not part of the record anymore because they're false and they'd be stricken. And yeah, there you go. So, this is a serious fucking problem, chat. It's a serious problem. And I think it's something, it's only getting worse. And there's so much of this now that it causes so many issues that, what is going to be acceptable going forward? What is going to be acceptable? So, the sentence is to be a non-licensed YouTuber lawyer. Yeah. All right, chat. So that's the end of it, but it's just a cautionary tale in this world. And honestly, I had some revelations tonight myself that maybe it's not a big deal, but I should be thinking about it. I'm going to have to ask. I got to send some emails out tonight, and then tomorrow making some phone calls. Like what, I might even call my malpractice carrier and be like, do you guys have any theory, any questions, or any input on this? Because I don't want to get fucking found liable. And I want to make sure I'm covered. Kind of important. But more importantly, even for attorney-client information, any calendaring software, if you use like Clio, that's a big legal one. But a lot of attorneys use? Google Calendar. Guess what? Google can see everything. The existence of clients, the existence of meetings can also be privileged and protected information. It gives you a lot to think about. J-Rock says, according to Elon just days ago, it hit a record-breaking 78% non-hallucinate, already number one in the world, smoking Claude, Opus, Gemini, ChatGPT, and every other model. That's bullshit. And they might not hallucinate on normal things, but in legal field, it's not going to be reliable. Tyler says, referencing me, you can find the page that contains this for a follow-up. Oh, okay, yes. Yeah, that's her. Jefferson Post says, what if you were to research in a public library? Yeah, let's say you start downloading or type up documents and leave them. Yeah, that could breach privilege too. Leaving things that are away there. Yep. J-Rock says, Sean likes men that are hard. Missouri Battlefield says, what if Trump says he was going to destroy your civilization? You were going to tell him because he told you to say uncle. Char. Embalm says, this explains the Cleveland Browns. Maybe it does. Blackfoot says, I'm going to take your hatred for us to the grave. Yep, I am. It's always chat's fault. Contestants used to be part of discovery. Yeah, Pixie's attorneys want to ask for it, but the discovery deadline, I think, is probably coming on by now. So maybe not. The use of AI turned Carl Jobst into Carl Lobst. Yes, Carl Jobst. Hello, you absolute legends. Oi, mate. Yes, he consulted with fucking AI and cited to defame Billy Mitchell, the hot sauce king. Topher says, "Can someone create an AI for legal purposes, where them not being a bar member make that not possible?" I mean, Westlaw did that, and Lexis have done it. They have protege and co-counsel. Not fucking reliable. They still hallucinated, and Lexis, like, for that, you're paying the top dollar for all that shit. And it's still fucked up. It's still fucked up. Elliot Johnson says, also, by the way, great questions earlier, guys. And still, what about legal research tools of AI interface layers? Lexis has an LLM layer in some of the tools. Not sure which ones they're using. You're still liable. That's not going to be an excuse. I won't touch that shit as far as I can fucking throw it. Now, there are times where, like, if you have a conclusion, and I know attorneys who have done this, they feed that shit into a LLM and say, punch up the language, don't touch the citations. Like, they'll say, punch up my conclusion, make it punchier, summarize my conclusion better. That's fine. You might say, well, wait, it's a but your filing is going to be public anyway, so that doesn't matter. Very, very limited use here. Chugi Show for $5 says, I ironically am in the middle of watching a movie of Chris Pratt called Mercy about an AI court. Yeah, I saw that. It's who knows how far away from that we are, really. Erica says, my fridge is AI. Yes, it is. It is. Mega Mobass, been a member for 3 months, or re-up for 3 months, says, hey, I finally caught a regular live. Well, thank you, buddy. Good to see you here. Ag Biochemist, been a member for 36 months. It's a long fucking time, guys. Thank you for being here this long, Ag. I appreciate it. And chat, I know some of you out there, you can't afford it, or you couldn't afford it the full time. Please don't take that as an insult. It's just numbers like that are humbling to see. And I know some of you have been here, they're here even longer than that. It says, Miss Hambley's holes are open just like the AI chat logs. Yes, they are. Turgo says, what I mean, lawyers are going to find these LLMs so useful. There's no way they're not going to allow AIs to have more attorney-client privilege protection eventually. There's no, like, they can't be reliable, though. There's things AI can do, but some of this can't be done. AI will still hallucinate. It's like, you're going to, like, it's not going to work. It can't work. Even Lexis can't make a non-hallucinating AI. So, what if they use Google search instead? That could be a problem. Joe Schmo says, my local LLM, whose training data set is only my published writing, hallucinates all the time. Well, that's, like I said, chat, it's scary. It's scary out there. Jefferson Post says, the mail has rules that we've taken for granted. Yes, it does, but the mail has a lot of rules and a lot of protection. But the way I had it explained best to me, sending out an email is like sending out a postcard. People can read whatever the fuck's on it. And then Mega Mobass for $19.99. Thank you. Says, oh, my other monthly dollar dues contribution other than membership. How dare you follow my best friend on X after I was the only one to introduce him to you? Lamau, just kidding. Get some white claws on me. Well, thank you. I appreciate that very, very much, man. Thank you for being here. Thank you for the support. And Luke says, what if you have a case? Do you have a case where the attorney defaulted through repayment? Yes. I've seen it. I have to go back through and look for it, but oh my God. There's a case or two where the attorneys have defaulted. Yeah. There's all kinds of sanctions out there. There's like tens of thousands of dollars, $50,000, $60,000 sanctions for having to discover and fix AI problems, chat. AI is not good, man. AI is bad news if you're not careful. It's bad news if you're not careful. So, Joe says, I pay for a publishing AI that does tone and engagement tuning, reading comprehension level, etc., but I still have to comb through its suggestions because of its hallucinations and syntax. Torgo says hallucination is not a foregone conclusion. I mean, if you could figure out how to make AI not hallucinate, you'd probably be like, that's like curing cancer, man. I don't know. I'm not an AI guy, but I mean, that sounds like that would be the final frontier, really, at this point. Non-hallucinating AI would be epic. That would you would win if you had non-hallucinating AI, and there's no guarantee for that now. Yeah, there's times where you can use AI to attack logic and things like that, and it's a battle of wills to AI to make it better, sure. But yeah. Peanut says, I wish my hallucinations had more Clyde appearances. Well, let's see if that'll happen tonight. Clyde had a big day because Bon left today. So he's been tired. Clyde. Hey, babe, where is he at? Clyde, come here, buddy. Come here, Clyde. Clyde, come here. Come here, Clyde. What's his deal? Chat, he doesn't like you anymore. He's like, I need subs, chat. He's like, I don't dance for nothing. Well, there you go, chat. He needs more peens. You need to give him peens or he won't answer. EDW Raptor for $5 says, when are we going to see a White Claw in your hand? It's been a while. We'll work on that. For now, it is, but these tools have only been around for 4 years. Am I supposed to believe we don't figure out within 10 years? I don't buy they won't figure it out. Maybe, but yeah, BLS. Thank you for being here. Yeah, I've read I've read the literature. Hallucination's impossible to get rid of. It's impossible. So AIs will never not do it. Yeah. No amount of RAM can fix the scaling issues. Yes. Not at all suspicious we're not getting proof of life. Yeah. Clyde hates you. Yeah, I know. No click clacks. I know. It's so sad. It's so sad. You blame Jeremy. I know. Jeremy's caused him to be sad. Eric says, being an official senior now, all communications I want to remain private are through my number station and one-time cipher pads. That's about the only way you can make that shit perfect. Yeah. EDW Raptor for 5 subs. Chat, that's the only way I can make Clyde happen right now. Hold on. Yes, there we go, chat. Hold on one more second, chat. I'll see if I can get him. I don't think that worked. I'm going to have to buy more weed treats, chat. I'm going to have to buy more weed treats. He's just not doing it. He's just not doing it tonight. So sorry, chat. Torgo the White says 78% of the time it works 100% of the time. Yeah. That's true. We would have to create, a new type of model to solve the problem. Yeah. That could be. Jordan Bemke says, warning! The North Central United States is suffering a cuck infestation. They're breaking out. Katie D says, good evening. Thank you for the gift and membership. Well, thank you. Thank you for being here. And yeah. I watch memes coverage of Jeremy. Yeah. Well, who doesn't like watching meme? Who doesn't like watching meme copium? So, but the thing is, guys, this is only going to get worse. Like, I bet we're going to get Supreme Court cases with fucking AI in them soon. It's going to be fucking hilarious. When, like, Clarence Thomas is like, counsel, did you know you put AI in here? Then Ketanji Brown Jackson would be like, I don't understand. Oh. Supreme Court can replace the AI. Oh, God, that would be even worse. That's even worse. That makes me panic a little bit on the inside. Oh, but maybe the AI will look, maybe everybody in the Supreme Court look hotter because remember the song, everybody looks really hot in AI. So there's already a ton of AI in those denied cert petitions. I know, but you're going to see somebody doing AI in like Neil Catal or like fucking Paul Clement or like some amicus brief that gets cert is going to happen. Bella says using AI makes us American. Yeah, because you're like, what do we do? Just go fucking send. You just hit send and you fucking send it. And you're like, what more American? How much more American can it be? David Hinkins says, I wonder how much KGB is only pretending to not understand.
It just don't make no sense.
It just don't, Chad. It just don't. Oh. It'll probably be a solicitor general, given how Colorado's been on 1A law recently. Might benefit them, yes. Oh, you're actually poking fun at KBJ, but cool. Oh, well, I mean, like, it's cool, but yeah, like, it's like, I thought you were just saying, like, it makes us more American. I think you meant like everybody, because we're just like, yeah, fuck it. AI doing it, so. Oh, there's a Jeremy implosion? Oh, okay. Well, if it's even worse. Joe says it's bad in the public industry. I have to warn my writers who are not using AI not to write like AI. That sucks. Really? So, interesting. Model time. That's 10:48. I don't know, guys. It's a little late. Depending on how long it's going to go, we were going to do a phone in, but we might save that for this weekend. Like Saturday, we might do a call-in show. How about that? How about that, chat? So AI has a style, yeah, with the dashes and everything. You know that. He's EP. Yeah, he's EP and some other stuff I can work on. So Kay says you sent some fun stuff. Yes, yes, you did. And that'll be good for tomorrow. Although I do think that, this is actually kind of worth watching real quick. Just as a little bit of levity. Your chat, if you want to see, yeah, Katie sent this. I saw this earlier today on Twitter, and I thought it was pretty fucking funny. So this is when the police grappler machine doesn't work. So here you go. So they're trying to grapple the car.
Grapple a vehicle traveling, in excess of a safe speed. Now, what the guidelines?
It's a fucking pit machine. Although to be fair, it stopped the car. Katie says the dude died. Oh well. I mean, like I said, mission accomplished. Though you stopped the car. I mean, these things happen sometimes. Oh, they showed the dead guy's body. Oh wow. Yeah. And now that guy owes that dude a new house. Well, the guy's dead. So, no, the house didn't stop. It's got a retaining wall. So, yeah, it's Bob's like, oh yeah, that's hilarious. Are you kidding me? It's meant to stop the car, and it's like, if the guy's family tries to sue, they're going to be like, no, it worked as intended. It stopped the car. Stop the pursuit. Brad says the boat's okay though. I have a feeling that boat's not in very good shape. I bet that boat's got all problems. But yeah, it's got a brick retaining wall. So, but yeah, there you go. Yeah, might as well just go full Arkansas Troopers at that point, yes. Could the homeowner get sued for that wall? No, because it's not like it's a booby trap or, people have heard about like homeowners like making a brick mailbox to prevent people from destroying it, and then they make basically like an obstruction in their yard. Like we had that issue here in Ohio where a guy like took like an I-beam and buried it like 6 feet into the ground, and a dude went off the road and hit it and almost fucking killed him. he tried to sue the homeowner for making a booby trap. And that, actually, I got to look up that case. We talked about it. It was interesting. I don't remember what happened. But yeah, imagine living that close to a fucking highway. Yeah, that's fucking crazy in California. That would be weird. Joe says, I bet that boat's an Airbnb. Oh my God, really? Is that what happens? Oh no. Oh no. Yeah, walls like that are for noise abatement. Yeah. So yeah, just don't run from the cops is another idea. Yes. So that's not a highway. Yes, it is. Are you kidding me? This dude's like on a multi-lane, like well, either way, that's really like you can't like
in excess of a safe speed.
okay, fine, it's a divided it's a multi-lane road. There. That's still ridiculous. Okay. So Missouri Battleflex, I have an 8-inch pipe full of gravel with a mailbox on it. Wolf, man. There you go. So yeah, we have wide roads in California. Yeah. Carl is mad as wall keeps getting busted. Oh, well, anyways, chat. With that said, though, that was kind of funny. A little bit of a palate cleanser for tonight. So yeah, just don't fuck around with AI. It's a warning to you all out there. Be careful. And like I said, guys, I have things I need to think about now. So, Missouri Battleflex, send you a picture tomorrow. Cool. Please do. All right, chat. With that said, we are all going to wrap this up for tonight. Remember, guys, join me for the Thursday night stream. Tomorrow night, we got all kinds of stuff. Rex Hoyerman, the dildo beach strangler, strangling them hookers and dismembering them up and down the Long Island coastline, pled out. We've got all kinds of stuff to talk about. An update on Hannah Dugan, the judge who got convicted. There's an interesting criminal prosecution in Australia. Basically kind of like their Chris Kyle. Was being prosecuted for war crimes and murder for things he did in part of the Australian SAS. We're going to talk about that. Steve Bannon is probably going to get his conviction overturned. And a couple of different other things that are out there, chat. We're going to take a look at those and go forward from there. Update on some Tyler Robinson stuff as well. And we'll address that tomorrow night, 9:30 Eastern, chat. Yes, don't forget to like and subscribe. Are we going to watch Casino? Well, I'm going to watch Casino while I do some stuff there. Kayla says, don't call him Hoyerman. It's Hewerman. 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 Or is that Hueyerman? Is that hue like a hue of color? Is that like the Brazilian LOL where they go, Huey. Not, instructions not clear. Instructions not clear. It's Ho-Man, Sar. Yeah, if he's murdering hookers, it's Ho-Man. Jewerman. Hue like color or man. Okay. Luke says Jewerman. Well, I don't think he, if you murder and dismember people, do you have to keep kosher while you're doing it? That'd be funny. That's actually a question. Like, if you're butchering them, do you have to like keep kosher on your tables and everything? Anyways, chat. You guys all have a great night. And remember, until next time, just because you did it doesn't mean you're guilty. Don't use AI, chat. Don't use AI. Kay says he's from Massapequa. Isn't that like in Nassau County or something? I don't know. Well, all the witnesses described him as an ogre. Yeah, well, but, that's why being a whore is a very dangerous job. Good night, chat, and take care.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains.
It's Kay's neighbor!
Had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on Just 'cause you did it doesn't mean you're guilty. But please talk to a local attorney.